Ms. Mallon. Ms. Dalton, good morning.
Good morning. May it please the court, good morning, Madam Chief Justice. Sarah Dalvin here on behalf of Carrie Clark. Ms. Clark is challenging the appeals court's denial of suppression order issued in January of last year on the basis that the environmental police officers' combined acts of pulling his cruiser up closely to the car in which Ms. Clark was a passenger, which was parked in a public area on a summer evening, a summer night, and activating the takedown lights on the overhead light bar of the vehicle constituted an unlawful seizure in violation of Fourth Amendment and Article 14 of the Massachusetts Declaration of Rights because the officer lacked the requisite reasonable suspicion to believe that any criminal activity was afoot.
So if the officer had simply approached the car with a flashlight to inquire, that would be okay?
Under the state of the case law, that would most likely have been acceptable and would not have given rise to any constitutional implications.
If these lights had not been called takedown lights, would we be here today?
That is a very good question. I believe the nomenclature is not benign on that. However, I think beyond the nomenclature, I think that the location of the lights on the overhead light bar is of some significance.
So a spotlight on the driver's side door shined into the cabin section of the car would have been okay.
Again, the Massachusetts case law seems to suggest that the use of the spotlights is less intrusive. I think Commonwealth versus Grandison was a case where a spotlight was used to shine down an alleyway where they saw the defendant spit something out, and that was found not to give rise to any Fourth Amendment or Article 14 issues.
So it's the location and not the color, right? I mean, you would agree with the motion judge that blue versus white is irrelevant.
Yes, I believe he used the term a distinction without a difference. That is what we would argue, yes. Again, the position on the overhead light bar, that is such a unique characteristic of emergency and law enforcement vehicles.
Well, they have wigwag lights, blue wigwag lights, whatever they're called, in the grill. Some cars do.
Yes, that's true. And again, this is, there's been no judicial notice or any definitions of the functions of these various lights, which I think in part is why we're here. But we have to look at what a reasonable person would believe. I mean, some lights are bright, but they're used for illumination purposes, and the blue lights are pretty distinctive and pretty well understood by everyone to be a signal to stop if they're behind you or yes.
anywhere near you.
Yes. And again,
What about the quote? I thought that the quote from Commonwealth versus Kavanaugh was very powerful. If policemen are to serve any purpose of detecting and preventing crime by being out on the streets at all, they must be able to take a closer look at challenging situations as they encounter them. Isn't that all that happened here?
well, Your Honor, I would argue that this was not a challenging situation. This was a public area. It was a public boat ramp. It was commonly used. It was the July 2nd. The case law in Massachusetts and elsewhere talks about the issue of cars being parked on a winter night as bringing up perhaps issues of safety, where the use of the lights in combination with the other factors doesn't give rise to any constitutional issues. However, this was a summer night. Many people use this boat ramp. The record indicates that the officer pulled into the lot and saw that there were two people in the truck, that they weren't doing anything, they were sitting there, that there was some debris outside the truck. All this he saw with the low beams on his cruiser on, and not with the use of the overhead light bar.
What town was this in?
This was in Belchertown.
When you say it was a public area, it was in the rural area. It was in the woods, wasn't it?
The boat dock, wasn't it?
It's a boat dock, yes. In the woods, it is definitely in the rural area.
Were there any overhead streetlights on?
There were no streetlights illuminating the boat ramp, no.
And how close was the nearest house?
That I do not know.
Well, following up on Justice Hyland's question, what are the police supposed to do? Forget that it wasn't a, what was the word that you used there?
challenge?
It wasn't a challenging area, but the police come upon an area and it's too dark for them to really see what's going on. Are they not supposed to use additional lights, and so then they aren't to be able to see a gun or something like that?
Again, I would argue that this was not a case where the officer couldn't see what was going on. The record indicates that he saw everything essentially that was going on before he activated his lights, and there was nothing.
Well, it was
to-
11:30 p.m., right?
Yes, it was. However, the boat ramp, the use of the boat ramp, the regulations indicated that people could park their cars up there for up to 72 hours.
Ms. Dolman, does the record indicate what the police were doing there at that time?
Yes, he was on routine patrol. I believe he testified that he had just come off the river doing boat patrol, and he was swinging through the lot, which he...
It was an environmental police officer.
Yes, it was an environmental police officer.
And was there, is there some indication as to why there was a patrol of this area?
No, no indication. He simply said that he was going through there on routine patrol. There was nothing in the record to indicate that there were crimes there in the past, that this was a high-crime area.
Well, officers, I mean, in localities, I mean, in most towns, the officers at night there are all kinds of patrols out. They sort of drive around. If they see something that's curious or unusual, they'll pull over and say, "You all right? Anything going on here?" Or, you know, I mean, that's pretty common. They don't have to be investigating anything in particular. And that sort of strikes me as what's going on here. And it seems to me the only question is whether turning those lights on changed what is otherwise a fairly routine encounter.
You cite a bunch of cases from other jurisdictions where you make the argument that the takedown lights have resulted in motions to suppress being allowed. But it looked to me, at least at first glance, as if most of those cases involve something besides takedown lights, such as red lights, or preventing the car from leaving. And in our case, I think that's the only thing on which you're relying.
Actually, if you look at the photographs that were submitted by the Commonwealth, I believe you probably have the originals, but it makes clear that this car, this environmental police cruiser, was parked very close to the other vehicle in a very large lot.
Was it preventing it from leaving? Was it in a position?
It was not blocking its egress. However, it would have the other car. And I believe at page 31 on the record, the officer testified that Miss Clark's car, the car of her that she and her companion were in, would have had to pull around to get out of the boat ramp because essentially the exit was behind, and the cruiser had parked in such a way that they would have had to pull around.
But the cruiser was not blocking
The cruiser was not blocking them. It was, we would argue, restricting their movement, but not blocking them. Also, again, the photographs, I believe, are really clear indicators of how close in this very large space this vehicle got. And that it was parked, it didn't park behind or
But
30 feet away. It parked perpendicular, shining the lights right into the driver's side compartment.
Why is the closeness important? I mean, the officer was there on routine patrol. I think it strikes me, he had every right to inquire, you know, of them, or at least to check on them, check on the car. Ordinarily, the cruiser might have pulled up right alongside and sort of said, "Everything all right here, folks?" or "How you having a nice evening?" or something, just to sort of check to make sure there was nothing that was such that further investigation or action were required. So how does the closeness matter? Other than blocking, how does the closeness matter?
Your Honor, the closest matters under the Mendenhall and Cook standards that, and again, not just the closeness, we would argue, but also the manner of the approach, the perpendicular shining right into the driver's side window, that under these circumstances, the reasonable person would not feel that they were free to leave. It's difficult to make this argument about the takedown lights without a specific definition of their function, their placement, etc. However, the case law suggests that they're very bright, and the officer himself testified that they were bright, and there's potentially blinding the occupants of the car. So the argument is that these combined acts, when there was no indication that there was any criminal activity afoot constituted a show of authority for which.
Well, assume for a moment we agree with you, and so we write our opinion to advise police what the rule is in the future on how they're to proceed. What do we say to them? You can't look at something unless it's obvious, there's obvious crime being committed? Do we say you can't park perpendicularly to a car because that's an intrusion? Do we say you can't use real bright lights in order to see because that's bad? What do we tell them?
Your Honor, the jurisprudence here is so fact-driven. I don't believe it would be constructive to issue bright-line rules about these situations because every situation is so independently fact-driven. Again,
but here you say the way they parked was part of it, the brightness of the lights was part of it.
Again, in most of the jurisprudence in Massachusetts and a lot of the jurisprudence in the other jurisdictions that I cited, there was some indication, there was some initial indicia of concern to the police, either when they approached the defendant, did something slumped down before they activated their lights, or there was some anonymous tip that they went to follow up on, a suspicious vehicle parked in a certain place. Here, again, there was nothing on the record to indicate that there was any criminal activity afoot or that this was a place where criminal activity was often afoot.
But it sounds like you're suggesting, in a way, that part of your argument is that the police officer should not have even, forget the light, should not have approached the truck. And that...
No, Your Honor, I don't believe that's my argument. I firmly believe that the police have a right to investigate, and I'm happy that they're out there doing that and protecting our society. However, in this circumstance where the officer already was looking with his low lights on his vehicle at the vehicle in the surrounding areas and did not see anything that would give rise to any concern, then it wasn't a winter night. There was no indication that anyone needed any aid or assistance. There was another case in Massachusetts, I believe, where the officer approached a vehicle in a high crime area late at night in a parking lot, and the car was off, engine was off, lights were off, windows were fogged. In that circumstance, the takedown lights were used to illuminate the area and ensure that the people were safe, and also to protect the officer's safety. But here we had none of those indicia present.
We have the woods. I mean, isn't the officer entitled to illuminate a greater area than just the car to see what else is going on in the surrounding? There are no other houses around. It's a public boat ramp at 11 o'clock at night. People don't usually launch their boats in the middle of the night. Maybe they were looking for a friend who was in the river and maybe was drowning. I mean, what's the police officer to think in these circumstances, instinctively?
And add to Justice Spina's scenario, there were items strewn about outside the car, which is...
Well, again, there was no indication that those items were connected to the car.
Well, they were close to...
They were in close proximity. That was the testimony. However, it was also a holiday weekend. This was an area that was frequented by boaters and people who drove in their trucks. It was also...
Yeah, but at 11 o'clock at night?
Well, again, the regulations allowed parking at any time of the day or night.
I'm not saying it's illegal, but it's seldom used by people at that hour.
There's some indication of bullhead fishing?
Yes, bullhead fishing. There was indication on the record that fishing and hiking were other activities that were conducted at the boat ramp.
But that's a nighttime activity, right? Bullhead fishing?
I believe it is, yes. I believe it is. So the fact that using the lights that he had on his vehicle that are common to all vehicles, the low beams, that he was able to see this benign debris, none of which in and of itself would give rise to any concern, that the people were in the truck, that they were sitting there still in the truck, if there was some need for assistance or if they were looking for a friend that was in trouble, I would argue that there would probably be some level of agitation that would be obvious to the officer. There was nothing here, and the officer saw that prior to pulling up in that perpendicular fashion and shining the overhead lights into the compartment. And I would argue that looking at, again, because this is the appeals court's opinion seemed to argue that this was sort of a settled question of what the function of the takedown lights were. We only have this civil case definition involving discretionary functions in a Tort Claims Act that the...
Thank you, Ms. Dolvin. Your time is up.
Thank you.
Ms. Pietzles? Good morning.
Good morning. May it please the court, Judith Ellen Peaches for the Commonwealth.
Could you help us, please, would you describe these lights? You know, how big are they? What exactly, where on the car are they, et cetera, et cetera?
There is nothing in the record as to the wattage for the lights.
Oh.
It is clear from both the exhibits that are at pages 50 and 51, as well as the officer's testimony, that there is a light bar on top of this F-150 pickup truck, and that the way it's set up is there's a blue light, a white light, a blue, then there's two blanks, and then another blue light, white light, blue. And then at either end, facing perpendicular to the truck, are white alley lights. The lights that the officer activated were the two white takedown lights that are on top of the light bar.
Ms. Pietzles, excuse me for interrupting you. Why are they called takedown lights?
I have not been able to find any information about that. Certainly there is nothing in the record on it.
Okay.
And I will...
Did the police officer use the term takedown lights?
He did.
Okay.
And while it's not in the record, I Googled this yesterday to see if I could get some information on it. And there are a number of sources that sell takedown lights to police officers, but nobody identifies them.
But he didn't say why he called them takedown lights.
No, it appears to be, you know,
Were
like
they-
Kleenex is called Kleenex.
Are they, actually, that's a name of a company, but anyway.
Right. But
are
the
they,
takedown lights may be as well. I'm not sure.
were they flashing?
No, these are not flashing. And in response to your earlier question, there is a distinction as to the color of the light, because universally in Massachusetts, the blue lights are used by police officers to indicate that you have to stop. And in fact, the legislature has precluded anyone but certain enumerated healthcare providers, EMTs, fire department, and police officers from using either oscillating or rotating blue or red lights. But there's absolutely no statutory prohibition about putting white lights on the top of your vehicle for use. And in fact, and amber lights are also used by law enforcement in some states, and I think that's what's difficult with some of the case law. They refer to the emergency lights, and you really have to look beyond the certain opinions to find out what's determined to be emergency lights within the jurisdiction. But as you go through it, you see that it's flashing or oscillating red lights, blue lights, or amber lights, but in no regard is it the white lights. The spotlights, the alley lights, and the takedown lights
They're all steady lights.
are steady lights, and they're all perceived to be the functional equivalent of a flashlight.
What is the bright line rule you would like us to?
I think the bright line
impose?
rule is that the use of artificial light to illuminate an area when it is not the talisman of authority, such as the sirens, the flashing blue lights, or the flashing red lights, without more does not constitute a seizure.
Even when there's no indicia of any crime?
There doesn't have to be indicia of crime when you have an officer in a public area doing what he's allowed to do, and he didn't do anything that would amount to a seizure of these defendants prior to telling them to put their hands on the dashboard.
Well, your sister says that the way he parked the car, in part, was a seizure, doesn't she?
She does indeed, but the difficulty with that is that that's not the record. And we have taken issue in our brief, both below and here, with the motion judge's finding or conclusion that the officer parked either next to the defendant's truck or close to the defendant's truck. The record
I thought
But
the
it was parked
judge had actually found that the police officer did not find that the police officer had blocked the exit.
Oh, definitely, but he did say that he found that the officer parked within 15 feet.
Which
The-
the testimony was 15 to 18.
15 to 18, so that there is nothing, because within 15 feet is less than 15 feet.
And the
How does
picture makes it look like the truck was parked, the officer's truck was parked perpendicular to the defendant.
And that's what the officer
Right.
testified to.
So that
He's-
so that the defendant would have a clear way to get out. I mean,
Absolutely, and I would remind the court that it's always the answer that's evidence and not the question. And the reference to page 31 in the transcript, it was the question by defense counsel was, in order for this vehicle to leave, he'd have to pull out around you. Is that correct? The answer was he could do it very easily. That's a wide open area. And then, you don't feel you were blocking? No, you can see that in the photo. No. And when you see it in the photos, this the question would suggest that there would have to be almost a slalom course maneuver in order to get out, but the reality is that that wasn't the case.
I can't understand why is it that you're so concerned about whether it was 15 feet or 18 feet or 20 feet, as long as it's not blocking? I mean, wouldn't it be ordinary for the officer maybe to drive up right next to the car to make inquiry?
Well, I
why is this so critical?
Well, it may appear to be tripping over toothpicks, but I think the fact remains that because there was the distance, that then it becomes unreasonable to claim that this was any form of an assertive show of authority.
I see. So in other words,
because there was the distance.
Okay.
You
All
know,
right. But
this wasn't confrontational, I think is what it goes to. So that where you've got the one officer by himself outnumbered in the dark ramp, and there's no blue lights, there's no siren, there's no vocal command, there's no conversation with the defendants prior to.
So it would be easier and less, I guess, nerve-wracking for the car to sort of, having seen the lights, simply drive off,
Yes.
as opposed to the officer having parked right next to them,
Right.
in a more confrontational kind of. Is that your sort of suggestion?
Well, that would be my suggestion, but that's not to say that there couldn't be a factual pattern that might exist where the officer parked immediately adjacent to the car.
Which would seem to be the most logical thing to do.
Well, especially where you know you're outnumbered, but you're not sure how outnumbered you are, because he could identify two people in the truck, but he didn't know certainly if there were more in the truck. And, or if there's somebody in the woods that has just left the
Okay.
truck and is about to come back. But in any event, in this instance, we have a considerable distance between the officer's truck, and the defendant's vehicle. And there simply is no case law anywhere that I've been able to find, or that the defendant has brought to my attention, that holds that takedown lights alone constitute a seizure. Rather, the case law, and I looked to the Justice one, which is takedown lights, and that isn't a seizure, because it is.
Well, the Vermont case, I think the police officer had blocked the car, right? There were takedown lights, but also the car
Right.
was blocked.
They had blocked, and in some instances, it's takedown lights with the emergency lights that, as the court looks further, you find out that those are flashing red or flashing blue. There was always something more.
Is part of the problem here the Mendenhall standard itself? I mean, we are sort of deciding case by case whether or not a reasonable person would have believed that they were free to leave. I mean, as a citizen, if this happened to me, I certainly wouldn't feel free to leave. I might know that maybe I could, but I wouldn't feel free to leave. But you're asking us to say, well, whether anyone in this courtroom would feel free to leave under these circumstances, as a matter of law, under Mendenhall, we determine that you are.
Right.
A reasonable person would feel free to leave.
And there has to be some standard, and it must be the reasonable man standard, reasonable person standard.
Has anybody ever left?
I mean, some people leave,
We
which is how
wouldn't
you get to
know.
Hadari, when the officer is yelling and screaming and saying, stop. Those people leave. So, some people leave when somebody pulls up, and we just never hear about it because nothing ever
I think
happens.
from a public policy point of view, what you don't want to do is have people leave in a way that creates more of a problem. So, I mean, as I looked at this case, it seemed to me you've got a single officer, it's late at night. He is checking, he can check, and he's illuminating it, it would seem to me, in part for his own safety.
Absolutely.
And, if people want to just roll up their window and drive away, nothing's stopping them. If they want to do that, they can do that. And if they choose to stay, they can choose to stay.
Right, in this instance, he wasn't putting himself or the defendants at risk because they were free to leave, and there was no way that their path of travel would have had the potential to injure him because there was so much distance in between the two
And
of them.
so you would say if someone left, that wouldn't be interpreted as some kind of consciousness of guilt, something that would then cause the police officer to say, well, something's up here. They left.
No, that's certainly,
As soon as I
and
showed up.
the decisional law is clear that the fact that you then flee, that doesn't give rise to reasonable suspicion absent more. And I would say that that would certainly be the case in this factual pattern, that had they left, they just left. The officer would have gone back into his truck, continued on with his routine patrol, and he may have picked up the litter prior to that, but that there would have been no consequence to these defendants at the time. And I guess I would rely on my brief, and absent any other questions from the court, I would ask that the court reverse the decision of the motion judge and vacate the suppression order and remand the matter to the trial court.
Ms. Petzlis, can I ask just one other question? In the decision of the appeals court, is there anything about that decision of the appeals court with which you take issue?
Well, I take issue with the fact that they adopt the judge saying that he parked within 15 feet. Because
Other than that, I mean, in terms of the reasoning of the court.
No. No, I think Justice Drebin summarized the prevailing law correctly, and that there isn't anything that has altered what was understood to be the standard in an encounter of this nature.
Thank you.